Yes, good evening, everyone.
Okay, ma'am. Good evening and welcome you all for the session on IPR series. Today we are going to discuss about handling pre-grant opposition. Let us start today's session with prayer.
Namo loyi savasahunam Keso panchanamo karo Sarva pava panasano Mangalanam chesadisam Padamam havai mangalam Padamam havai mangalam Neerarum kadaluduttanilamadan கெழிலொழுகும் சீராரும் வதனமென திகழ்வரத கண்டமிதில் தெக்கணமும் அதிசிறந்த திராவிடனல் திருநாடும் தக்க சிறு பிறை நுதலும் தரித்தனரும் திலகமுமே திலக வாசனை போல் அனைத்துலகும் இன்பமுற எத்திசையும் புகழ இருந்த பெரும் தமிழனங்கே தமிழனங்கே உன் சீரிழமை திரும்பியந்து செயல் மறந்து வாழ்த்ததுமே வாழ்த்ததுமே.
Today we have with us Mrs. Lakshmi Devi Somnath, Head IP, Surana International Attorneys, International Law Center, an alumnus of National Law School of India, University, Bangalore, and a gold medalist in her LLM. She was appointed as a judge of the IP Appellate Board, technical member of trademarks, and adjudicated in numerous cases on several key trademark law issues. Her orders ranged from declaring Good Day to be a well-known trademark to deciding in favor of RPG, HP, various famous trademarks. Enrolled in 2002 and practiced intellectual property law for 18 years, mainly before the High Court of Madras and also various other courts and tribunals. She has been arguing counsel in hundreds of cases concerning significant jurisprudential questions in intellectual property law, with over 200 reported cases to her name. She also filed and prosecuted many applications before the Indian Trademark, Design and Copyright Offices and coordinated the filing of trademarks and patents in various countries worldwide, including USA, UK, EU, Japan, Singapore, GCC countries, and PCT patents. She has co-authored the book Manual of Cyber Laws by Aditya Book Company in July 2010 and is a regular contributor to various regular publications and journals. She has been called upon to be the panelist in various conferences and was the associate editor, Chennai Law Times 2007-2012. Madam, we are really honored to have you here and thank you so much for your time. We know that you are busy and thank you so much for your time on enlightening us on IP laws and the related things. Now you can start the session, ma'am. Thank you so much.
Yeah, thank you for those kind words. Am I audible?
Yes, ma'am.
Yes. So thank you, and thank you for having me over in this program. I believe this is a series program where other speakers have also spoken on various aspects of patents, patent filing and all that before me.
Yes, ma'am. It is a series of 15 days, and today is the 12th day, ma'am.
Okay, fine. Okay.
We had an
So,
introduction of IPR, why IPR is important for the academicians, and there were various topics discussed related to IPR on first examination report and how to defend your opposition and all those things, ma'am.
okay, okay. So the topic specifically that I would be touching on today is oppositions, patent oppositions, specifically pre-grant oppositions.
Yes, ma'am.
See, as you all know, a person has an invention. He files a patent before the Indian Patent Office or before any other patent office the world over. The patent application has to get published, which happens in India in the patent office journal or the patent gazette. So the patent gets published. Once it is published and the inventor files a request for examining that patent, the patent is examined. Now, any time after publication of the patent application, once the patent is published, it comes to public knowledge. Everybody gets to know that, okay, for this particular invention, a patent has been filed by some person, and this is what the invention is about. A gist of the invention, also any particular figure that has been filed, a drawing that has been filed for the invention, all will come in the publication. So what it is open to the entire public for viewing, this particular journal. So what companies normally do is they keep a lookout for any inventions that come up in their particular industry, or any inventions that are similar to what they have already invented. If they come across anything that is similar to what they have invented, they say, okay, this is similar to what I have invented. So, I mean, how can this person file a patent for this? Okay, he has filed. So what can you do about it? So what they can do about it is oppose that patent. Once a patent is published, any person interested can file a pre-grant opposition against that particular patent. So the pertinent thing to note here is any person interested. You can be anybody. You can file once you show that you have a preliminary interest. Yes, probably the patent that is being filed is pertaining to pharma. You are a person interested in that particular field of innovation. You feel that this is a patent that should not be granted for certain reasons. There are grounds that are specified in the Patents Act, grounds under which a pre-grant opposition can be filed. So you can say that, this invention does not merit a patent because of these particular reasons. Therefore, I am filing an opposition to it. So you can say that you are a person interested and file an opposition against a patent. Now, in India, this is not a new concept. It is there far back, dating from 1911. So first we had the Patents Act of 1911 in India. The concept of pre-grant opposition is there from 1911. And later on, we came up with the Act of 1970, the Patents Act of 1970. Then we came up with amendments in 2003 and subsequent amendments. So the section for pre-grant opposition, the legal provision for pre-grant opposition has sustained from 1911 till date. And right now, section 25(1) of the Patents Act and Rule 55 of the Patents Rules deals with a pre-grant opposition. So pre-grant opposition is, a unique opportunity that is granted to an organization or an individual to challenge their competitors' pending patent applications. See, once a request for examination is filed by the person who filed the patent office will take up their application for examination. They themselves will examine the patent. They will look at whether the patent is novel, that is, whether it is new, not heard of in that industry, whether it has inventive step, and whether it is not obvious, that is, nobody thought of that particular invention before. All these they will look at before granting the patent. But at the same time, if somebody has an opposition to that patent being filed because of certain grounds, you can also file a pre-grant opposition on your side. In addition to the patent office examining that particular invention and determining whether it is patent worthy or not patent worthy. So the opposition can be filed from your side also. Once you file the opposition, the patent office is alerted to the fact that, okay, some person has filed an opposition for this particular patent. So yes, probably there is something that needs to be examined. Why has an opposition been filed? They examine that particular opposition and they see. So there are two kinds of oppositions, pre-grant and post-grant. Now, regarding pre-grant opposition, it is a very effective method to oppose inventions that are undeserving, that are frivolous, that have been wrongfully obtained, that is probably known in the art for a very long time. It is part of the normal everyday working of inventions, but somebody has now come and filed a patent for this. So it is known in the art and wrongfully filed for a patent by that particular person. So all these are points that you can highlight in the pre-grant opposition. So after the patent is granted, a post-grant opposition can be filed. Opposition before that is pre-grant, and a post-grant opposition can be filed only by a person who is interested. So a pre-grant opposition can be filed by any person, and a post-grant opposition can be filed only by person interested. Now, all these are time-barred activities. For example, a pre-grant opposition cannot be filed after the grant of the patent. Then you have to only file a post-grant opposition. It is very advantageous to file a pre-grant opposition because you need not show that you are a person directly connected with the patent in any manner. You need not show your interest. You can just file it. You can be any person. So it is very advantageous to file a pre-grant opposition before the grant of a patent rather than waiting for the patent to be granted, taking your time to make your decision, and then looking at what decision the patent office will take regarding its patentability. The moment you see that the patent office is inclined to grant the patent and it is granted, then going and filing for the post-grant opposition, you would need to show that you are a person interested. So it is easier to file a pre-grant opposition than a post-grant opposition. And this is a very good way, a business strategy to stop competitors from monopolizing the market regarding any particular invention and to effectively stop the grant of an undeserving patent. So the procedure for pre-grant opposition is to file a statement and also evidence that supports the statement stating why this particular patent should not be granted. Why are we opposing it? So this is the gist of that particular statement that is filed. A request for hearing can also be filed along with a pre-grant opposition. So it has to be filed within 6 months from the publication of the patent application. And the opposition that is being filed will be considered by the controller of patents. A hearing may be called or not. Normally, the pre-grant opposition that is filed is taken up only if the inventor files his request for examination. Otherwise, it is not necessary to take up. See, if a request for examination is not filed for a patent application, then it lapses. That particular patent will not be examined by the patent office. Whether it is patentable or not will not be looked into by the patent office. The patent office would merely, push it aside, not a patent for consideration, not a file for consideration, and move on to other patents where requests for examinations have been filed. So when a request for examination has not been filed for a patent, up to then there is no need to consider the pre-grant opposition also. So any person can file a pre-grant opposition once a patent is published, but such pre-grant opposition will not be considered unless a request for examination is filed by the inventor for that patent. And once a patent is opposed, a pre-grant opposition is filed, the notification of that is also sent to the inventor. So the inventor knows, oh, somebody has filed an opposition against a patent that I have filed. Okay, who has filed it? Okay, this particular person has filed it. On what grounds has it been filed? Oh, on these particular grounds. So all this will be looked at by the inventor. The inventor would then take a calculated decision as to whether to proceed with that patent or not. They may even decide to, leave that particular patent. Probably they may feel that it is not worth to proceed with that particular patent now that a pre-grant opposition has been filed against it. So this is the advantage of filing a pre-grant opposition. It is an effective way of blocking competitors who would probably think of filing inventions for something that is very known in the art. For example, there may be a particular device that is used to separate the various components in conglomeration, in a particular chemical conglomeration, and there is a device that can be used to separate A, B, and C from a particular chemical composition where A, B, and C exist together. This may have been known in the art for a very long time, probably 20 years, 25 years. Suddenly, a pharmaceutical company comes across a patent that has been filed for this particular device by its competitor company. So what the competitor company has done is to make a very mere workshop modification in that particular device and then file for the patent. A very smart move, so that they can now get the monopoly over the use of that device. And then later on, if anybody attempts to use that particular device, they can always, claim the monopoly rights over it and say that, see, you have to pay the royalty because we now have the patent over that device. So once the pharmaceutical company detects that its competitor has filed for this particular machine device, it can file a pre-grant opposition saying that this is something that has been existing for 20 years, so 25 years in the art. There's nothing new about it. There is no inventive step or nothing novel or nothing non-obvious, nothing that merits a patent. It is there for a very long time in the art. And they have just, made a mere workshop modification for the purpose of filing this patent. It is not an invention. The existing device, they have merely made a workshop modification and now they are filing it for a patent. So it has to be stopped. The moment the pharmaceutical company files this particular pre-grant opposition before the controller of patents, and intimation regarding this pre-grant opposition is also sent to the inventor company. The inventor company sits and takes a calculated decision. It thinks, okay, when we file this device, for this device, we thought, okay, we could, secure monopoly rights on this particular device. But now someone has come to know about the patent through the publication, and it's a competitor company, and they have filed a pre-grant opposition against us. So now we have to take a decision as to whether to go ahead with this patent, because we also know it is only a workshop modification. We were just giving it a try. Let's try whether we will get a patent or not. So now, since a pre-grant opposition has been filed against us, probably we should back off and not proceed with the patent further. So let's not file the request for examination. Such situations also happen. So that is the advantage of a pre-grant opposition. Your competitor company may back off at that stage itself and not file a request for examination and pursue the patent further. So the advantages are either your competitor backs off at that stage, or your competitor files a request for examination and the patent is taken up for examination. At that point of time, the controller of patents also takes up the pre-grant opposition for consideration and then asks the inventor to file their response to your statement and evidence. Why exactly does the invention merit a patent? how exactly do they counter the grounds that you have raised in your pre-grant opposition? So the controller looks at whether it is satisfactory, looks at whether a hearing should be scheduled, and after all this decides whether the invention merits a patent or not. So there are two levels on which you can succeed in your pre-grant opposition. Either preliminarily itself, if your filing itself dissuades the patent holder from proceeding with the patent further, or you file the pre-grant opposition, he also decides to proceed with his patent, then both parties come together and controller decides on whether the invention is patent worthy or not. So after considering the statement and evidence filed by the applicant also, the applicant is given 3 months time to file his statement and evidence after the notification from the controller. After he files his statement and evidence, the controller looks through both and he may either refuse the grant of the patent, or if he feels that an amendment of the patent specification may solve the problem, may overcome the grounds that have been raised in the pre-grant opposition, then he may direct the applicant of the patent to amend the patent. So if the problem is solved through the amendment of the patent, if he feels it is fine, then the controller will proceed further and grant the patent. Or if he feels that the opposition is not overcome through any of these means, then he rejects the patent. He refuses the grant to patent. So he will either reject the opposition and accept the patent and the patent proceeds towards grant, or he will refuse the opposition and allows the patent to proceed towards grant. One of these two things will happen. So a rejection by a controller of a pre-grant opposition is not an appealable one. It cannot be challenged at that stage. After the particular patent is granted, an action can be filed before the courts to revoke that particular patent on the particular grounds that you would have maybe raised in your pre-grant opposition, new grounds also that you may have. So that patent revocation can be filed at that particular point of time. But an order that is given by the controller of patents in a pre-grant opposition is not an appealable order and cannot be challenged in writ petitions before the High Courts, because there are further remedies available. You can file a post-grant opposition, or even after the post-grant opposition, you can file a revocation against that particular, the grant of that particular patent. All these remedies are there. So overstepping all these remedies, you don't need to jump above all these remedies and approach the court against an order that is passed in a pre-grant opposition. And after pre-grant opposition comes a post-grant opposition, which, as I said, can be only filed by a person who is interested. It is of a more limited range because naturally it limits the applicant. And post-grant opposition has to be filed within 1 year from the date of grant of the patent. Just like a pre-grant opposition has to be filed within a particular time period after the publication of the patent, post-grant again is within a particular time period after the grant of the patent. So after both these, the right closes. And the grounds that are available for both are the same, whether it is a pre-grant or whether it is a post-grant. So a person, when filing a pre-grant opposition, the route is clear, you can be anybody. But regarding a post-grant opposition, you have to be a person interested. What does a person interested mean? How exactly do you show that you are a person interested? Where the benchmark is set a bit more high by our lawmakers. You have to show that you are a person interested to oppose a patent that has, finished passing the scrutiny of the patent office. Patent office is saying it can be granted, but then you are saying that you are opposing the patent. So you can't be anybody. You have to be somebody interested. Who is a person interested? A person interested is somebody who has a direct, a present, and a tangible interest in a patent. That is, if that patent is granted, it will adversely affect that person's rights. So this was held by the Honorable Supreme Court. 2014 decision of the Honorable Supreme Court of India in Alois Woben case. The court held that there has to be something shown that by the grant of that patent, the person who is filing the opposition, his rights will be adversely affected. The same example we can take. See, the pharmaceutical company either did not file a pre-grant opposition, or the pre-grant opposition was refused, and this particular patent that its competitor company has filed for a device, it proceeds towards grant. The patent office feels that it is grant worthy and says, okay, fine, patent is eligible for grant. So now the company comes up with a post-grant opposition. So in the post-grant opposition, it has to show that, see, not only its company, but also everybody in the market will now be adversely affected. Because now this company, which has been granted the patent for that device, a device which every pharmaceutical company has been using for the last 25 years in the market for the separation of an ingredients in a composition, they will now start asking for a royalty payment from all these companies. And it is nothing new. So a patent should not have been granted. So this will have to be proved that they are a party interested because it adversely affects their rights. Everybody in the market has a right to use it. It is part of the public domain. These people are now encroaching on that right and claiming a monopoly over something that is already in the public domain. So that will have to be proved by them. And they have to show how they will be adversely affected, which is when they can show that they are a person interested and that they can file a post-grant opposition. And the pre-grant opposition has to be filed before the controller of patents. And if he is of the opinion that a patent against which a pre-grant opposition has been filed, the pre-grant opposition need not be taken up, and he refuses it, the patent proceeds towards grant. But before that, whether a hearing has to be mandatorily scheduled or not, even a hearing is not mandatory. The controller can take a decision that a particular pre-grant opposition that has been filed need not be a bar to the grant of a particular patent, and he can proceed towards the grant of that patent. So it is the discretion of the controller as to whether to give a right of hearing or not. In a post-grant opposition, a right of hearing has to be given to the person interested, and the party has to be heard before the controller takes a decision on that particular post-grant opposition. So in a pre-grant opposition, the controller can give a hearing, or he may decide on the matter without a hearing. It's at his discretion. The Patent Act in section 2 also defines a person interested. It says a person engaged in a particular, the same field, or doing research in the same field, or promoting the same kind of, same kind of machinery or same kind of process that is in the same field. So basically, a person who has been in that which the invention relates, and a person who knows that particular industry, a person who can authoritatively speak on that particular thing, a person who is affected, such persons will be considered as persons interested. So as per the definition that has been given by the Supreme Court, the person has to show that his rights are adversely affected. And as per the Patents Act, he has to also show that he is a person who is also in the same industry, the same field. Now, one major thing is when cases come up before the high courts after the patent has been granted, the court always looks at whether this patent whether any earlier challenges have been filed against the patent. That is, whether any pre-grant has been filed against it, or post-grant has been filed, or a revocation has been filed. And in all those actions, the patent office has said, yes, the patent can be granted. Yes, the patent is grant-worthy. Yes, the patent is grant-worthy. After all this, then a patent comes to the court. Somebody's filing, saying that this patent has to be revoked. It is not patent-worthy. The court will look at this. So this has been held in the 3M case by the Delhi High Court. The court said that in that particular case, there was a patent for a particular invention that had been granted in US and in India. And in both cases, both countries, the invalidity of the patent had been tested through the filing of pre-grant oppositions and post-grant oppositions. Through all that, the invention withstood. And the patent office said, yes, this invention is patent-worthy. It can be granted a patent. It is worthy of a patent. So then, the court told the defendant, the plaintiff's invention has withstood so much and it has reached the stage. And now there is a patent on it. So now your burden of proof is all the more. You have to, really show us how exactly we can declare it invalid. When they have come out of a pre-grant opposition, they have come out of a post-grant opposition, and now you are challenging that same patent before us again. So when so many people have deemed it grant-worthy, now you have to show us really how we can hold it as invalid. So the filing of pre-grant oppositions against a particular patent and they are coming out of it is taken up by companies to show the worth of their patent if it is later on challenged in any of the courts. Now, what would be the grounds under which you can file a pre-grant opposition? One of the first grounds is wrongful obtaining of an invention. So what exactly does the wrongful obtaining of an invention mean? It is that the patent has been wrongfully obtained. That is, you did not have rights on that invention. Someone else had rights. That should have been the person to file that invention. Instead, you go and file a patent for that invention. So you are not the inventor. You never were. You are wrongfully claiming that you are the inventor. You do not have any rights absolutely over that invention. That is one of the grounds on which a pre-grant opposition can be filed. As per section 25(1), section 25(2), and section 64(1)(c) of the Patents Act. So this is the first ground. An example would be probably a particular employee of a company who was working in the company. He developed a technology, he developed a device or a process or a method, and he left the company for some reason. He then goes and files a patent for that in the patent office in his name, saying that he is the inventor and he has developed this particular invention. As you all know, all employees are bound by their employment agreements their non-disclosure agreement, and also whatever works they develop during the course of their employment is developed as a result of their employment with the company. So therefore, it is all inventions ultimately owned by the company, always. So he has filed this particular invention in violation of that. Now, when that particular patent is published, the company who was formerly his employer has the option of filing a pre-grant opposition, stating that this particular patent is it is not an invention that was designed by him out of his own skill and labor and out of his own intellectual input. He was working in our company where he was given a particular work protocol, and he was mandated to innovate on these particular aspects, and we also gave him requisite training and enhanced his skill sets for this. He was also working as part of a team. He was not a solo member, and out of the course of all those efforts, this invention came when he was working with us. So the invention was never his. It is wrongfully obtained by him, this particular patent. So this is how a pre-grant opposition can be filed on this particular ground. Now, another ground on which a pre-grant opposition can be filed is anticipation by prior publication anywhere in the world. So even though we are now talking about the legal grounds on which an action for pre-grant opposition against a patent for an invention can be filed in India, this ground is beautiful, as in, it encompasses a technology everywhere in the world. So this ground says that if there is a prior publication anywhere in the world, that is this particular invention, it has been published anywhere in the world, then it cannot be applied for as an invention in India. And on that ground alone, this particular patent has to be rejected. So this is section 25 2B. The invention that is claimed is not new. The invention that is claimed is already publicly known before the date of the filing of the invention. The invention claimed is known either anywhere in the world or in India on a date prior to the date of filing of the invention. So these are the documents that can be shown to substantiate our point. See, there is this particular magazine publication which shows that people are using this. Or see, so many articles present in Google, even Wikipedia, which shows that this invention is known in the industry for past 30, 40 years. Or see, certain invoices and vouchers of us that's dates 10 years back, which show that we have been using this even before. So there is prior knowledge. It is not new. It is not novel. This is the second ground on which pre-grant opposition can be filed. Going to the third ground, that is, a patent has already been filed in India for that invention. So the invention that is being claimed by that patent you want to oppose, a patent has already been filed for the same invention in India. There is prior claim in India. So if that is the case, then also on that ground, a pre-grant opposition can be filed. So if there is an invention with the same complete specification, same claims, it has already been claimed in India, then on that ground, a pre-grant opposition can be filed. This is the third ground. Fourth ground, if there is public knowledge or public use in India before the priority date, then also the patent can be opposed. The fifth ground, if none of this is, proven, that is, the patent is, whether the invention is already known in the art, whether it is known elsewhere in the world, whether it is known in India, whether a patent has been filed before this for the same invention, none of that. Keeping all that aside, just simply the patent is obvious. Anybody can think of it. For example, like doorknobs. Doorknobs can be made of various materials. It can be made of wood. It can be made of metal, or it can be made of plastic. So a person files an invention for a doorknob that is made of fiber that has been derived from the strands made out of threads that are derived from plant-based material. So this is the invention, and through a process, the fibers are intermeshed and woven together, and they are subject to certain process whereby they achieve an amount of rigidity, whereby they lose their pliability and the flexibility, and they can be made into rigid matter. And doorknobs are crafted out of this material. So the patent is for the entire processing of the material up to the state where it can be made into a rigid structure. And the patent claims that this can be used for making doorknobs. The end result is the making of doorknobs. So the question arises whether this is patentable or not, whether there is actually an invention. Is there something new actually? Or maybe there are no doorknobs made out of a fiber that is plant-based till date. But isn't it obvious? I mean, there are doorknobs made out of wood, out of metal, out of plastic. What stops a person from inventing doorknobs out of some other material like fiber? That's all. So hard bound fibers for use in other industries are already known in the art. Probably fiber cover for a book, or maybe for wallets, or maybe for handbags. Wouldn't this invention just be a modification of that particular invention? So this is something called obvious and lack of inventive step. The invention is very obvious. Any small child can say, okay, this can also, what is the big invention in that? It is obvious and it lacks an inventive step. So this is the fifth ground on which a pre-grant opposition can be filed. Now, the sixth ground, the subject of the claim is not patentable under the Patent Act itself. See, there are certain things for which a patent cannot be filed under the Patent Act. For example, if it relates to atomic energy, or if it is something else that goes against the security of the country, or it goes against certain moralities. There are certain subject matters that are prohibited as patentable subject matter under the Indian Patent Act. So if this invention also focuses on something like that, then that constitutes a ground for pre-grant opposition. Of course, it cannot be granted. It is not necessary to prove any of the other grounds. The invention is prima facie not patentable subject matter under the Indian Patents Act. So that is the sixth ground of pre-grant opposition. Now, seventh ground is where there is insufficiency of disclosure in the patent. You are claiming a solution that can be used for cleaning of eyepieces, but you are not mentioning what the various ingredients in the solution, what the ratio of the various ingredients are. See, you may mention that there are 10 ingredients that are combined together to form a solution that is used for cleaning eyepieces. But unless the ratio in which the ingredients are combined are clarified and mentioned, there is insufficient disclosure. How would the patent office grant a patent? Because these very same ingredients can be used in different ratios to form various solutions that can be used for various other things. So you have to very clearly specify what exactly is the ratio in which it can be combined. And if the ratio is not specified, there is insufficiency in disclosure there. For such an invention, a patent cannot be granted. Therefore, a pre-grant opposition also can be filed on that particular ground, that there is insufficiency in disclosure, and the patent document that the inventor files does not fully and sufficiently and fairly disclose the subject matter of the invention in such a way that a layman who is reading that particular invention, or a person who is skilled in the art, he reads that particular invention, but he does not get an idea of what the invention is about. So he does not understand how exactly that invention is derived through these particular ingredients. Or if it is a machine, how exactly would these parts be joined together to form the machine? There is a machine A, B, C, D, E are the various parts in that machine, but the connectors, how exactly the parts are connected, is missing. Therefore, there is insufficiency in disclosure. Or if it is a patent for a method, that is this particular method by which probably soya chunks are produced. But how exactly the method of working? There is a certain lacuna or lapse, 2-3 key procedural things are missing in the middle. Once the soya beans are processed and once they are, they are boiled down to the raw, and once they are conglomerated to form the raw mass, and then they are subject to this particular chemical treatment, then they are subject to a water wash, whatever it is. So 2-3 of the key steps in a particular process or method is missing. So when that is missing, exactly how the invention works is not, the information is not sufficient. Therefore, that would be a ground for a pre-grant opposition. So this ground is insufficiency of disclosure of information. That is the 7th ground. The 8th ground is when the applicant has furnished false information. So this is also a ground. Suppose any of the information that he's supposed to furnish is false. His name, address, or probably disclosure. Have you filed patents in other countries? Yes, no. Which countries have you filed patents in? Or was this patent first applied for in some other country? If so, what was the date of the filing in that country, the priority date? If the applicant furnishes incorrect, false information regarding any of these parameters, then that is a ground for the filing of pre-grant opposition. Now, another ground is ground 9, where there is the non-filing of the application within 12 months of filing the application in a convention country. So in your earlier sessions on IP, when you discussed patents, I'm sure you would have come across various ways of filing patents. Patent you can file in India, or you can file a PCT patent application, otherwise known as an international filing, or you can file patents in individual countries that you want. That is, if a person is originally filing a patent in the US PTO, the United States Patent and Trademark Office, then within 12 months he has to file in India, if he wants to file in India and other countries also. So if the patent has not been filed within that 12 months, but filed only after 12 months, and this is a situation, then a pre-grant opposition can be filed. And the patent office can be alerted to the fact that, see, this patent was not filed within the statutory time period of 12 months. It was filed only after the 12 months. So based on that ground, you should not allow this patent. Patent cannot be filed after the statutory period. So that particular patent should not be allowed. Therefore, we are opposing it. This is the ground for our pre-grant opposition. So this is one of the grounds of the pre-grant opposition. Ground 10, non-disclosure of biological material that is being used within the patent. So if there is a non-disclosure or wrongful mention of any geographical origin of any material or the name of any biological material, this also is a ground for a pre-grant opposition. So there has to be a complete disclosure. If there is no disclosure or the disclosure is wrong, if mango leaves are used, mango leaves of which area, the particular geographical origin has to be there. It has to be disclosed that leaves of Mangifera indica are being used. So if that is not being disclosed or disclosure is not proper, that is a ground for pre-grant opposition. And 11, suppose the particular invention that the patent is claiming is already known in the traditional knowledge. And please look at this ground, it is very wide. Anywhere in the world, then that is a ground for pre-grant opposition. So this is again another beautiful provision within the Patents Act, whereby the traditional knowledge of a community is kept intact. So if somebody files a patent for something he claims as an invention, but you find that it is part of traditional knowledge that has been passed down to us by our ancestors from time immemorial, and not just in India, probably it is known somewhere else in the world. You would have probably come to know about it through various sources available to you, books, articles, media. So on that ground, a pre-grant opposition can be filed. That the invention that is being filed for a patent, it was foreseen in the light of the knowledge that is available with any local community or any native community. If that can be proved, then your pre-grant opposition would stand on that ground. And other than these grounds that are applicable for pre-grant opposition and post-grant opposition also, the only ground in all the grounds that I said that is not applicable for post-grant opposition is the ground where you can oppose where the patent is filed outside 12 months from the filing in the convention country. So that is the ground only for pre-grant opposition, not for post-grant opposition. For post-grant opposition, there are some additional grounds. The additional grounds are where the patent was granted to a person who was not entitled to apply for the same, and there the invention is not of any use. So that's a broad ground, and that is again left to discretion of the controller and of the courts. So where it can be proved that the invention is not of any use, the patent, a post-grant opposition can be preferred on that particular ground. Again, where the invention was secretly used in India before the date of the claim, any direction of secrecy under which the patentee was bound, that is a patent holder, was bound, but he violated that and he applied for the patent. If it has been obtained through false suggestion or misrepresentation, so all these are grounds for post-grant opposition. Now, in India, I'm sure you have all heard of the Novartis case, very famous case. Novartis Pharma versus Natco Pharma. So in the Novartis case, an application was filed for a pharmaceutical invention by Novartis. after the publication of Novartis patent application, a pre-grant opposition was filed by NATCO. And the grounds on which NATCO filed were that there was a lack of novelty. Patent was not novel, that's what they said. There was a lack of inventive step. And they also said that there was non-patentability. The invention was not capable of a patent. So after examination of the opposition, the controller was of the view that it did not merit a patent. There was substance in NATCO submissions. So he accepted the pre-grant opposition and he refused to grant the patent to Novartis. Of course, there was further legal battle between the parties, but that particular pre-grant opposition is one that succeeded before the patent office. Again, in Hindustan Lever versus Godraj soaps, 2 patent applications were filed by Hindustan Lever. They had filed those patent applications for detergents, one relating to washing fabrics, one relating to bathing. It was a bar that they had filed for, detergent bars. And they said that they had developed an improved product and they had developed an improved process for making that particular product. Now, this was objected to by Godraj. Godraj filed a pre-grant opposition saying that on the ground of prior publication, that is known. I mean, it is already there in the industry. All knowledge is already there in the industry. There is nothing new that Hindustan Lever has come up with. And they also said that there is prior public knowledge, it is very obvious, and that there is lack of inventive step. There is no invention, nothing. So why should they be granted a patent? The controller looked into this and the controller ordered for amending the patent specification. So based on the controller's order, Hindustan Lever amended their patent specifications. The patent document is the patent specification. They amended the patent specifications according to the order of the controller. Later on, the controller looked at the amendments and found that it was fine, and he dismissed the both the pre-grant oppositions, stating that the pre-grant oppositions here do not hold any substantial ground, since now the patent specification has been amended. Therefore, the inventions merit a patent. There was another issue that was heard by the Madras High Court, whether a person should be given a hearing or not. So the Madras High Court, in a case called Indian Network for People Living with HIV/AIDS versus Union of India. In this case, they decided on the question of whether the opponent has to be given a right to hearing before the controller decides, that is in a pre-grant opposition, before the controller decides whether to grant the patent or not. So this was a case in which this petitioner society, which is a society for people who were suffering from HIV/AIDS, they had opposed, they had filed a pre-grant opposition to a patent that was filed by Hoffmann La Roche, to an AIDS drug that was patent for an AIDS drug that was filed by Hoffmann La Roche. And the controller sent the notice of opposition to the applicant. The applicant filed their reply to the opposition that was raised by this petitioner society. Controller went through that reply and then granted the patent without giving any hearing to the opponent, the person who filed the opposition. So the Madras High Court discussed this and said that the petitioner has a right to hearing. The controller shall proceed with either rejecting the representation or granting the patent, or accepting the representation and refusing to grant the patent. since the patent granted was rejected, so they said that the opponent could have had a right to hearing, since the prima facie view of the controller was leaning towards the grant of the patent. Now, what happens when a pre-grant opposition is rejected? So when a pre-grant opposition is rejected, as we discussed, no appeal lies against that order. What the person can do is to file an appeal. He can file a post-grant opposition. Then he can go for revocation of the patent. He can do it by filing in the High Court or before the controller of patents, as he chooses. So that is a remedy that is open to him. And where a pre-grant opposition is allowed, that is, the controller of patent decides that there is substance in an opposition and he says, we cannot grant your patent. So patent grant is rejected. Then the person who has filed for the patent, what is the remedy that is available to him? He can appeal against that particular order of the controller. So earlier, the appeal used to lie before the Intellectual Property Appellate Tribunal, which was a tribunal that handled intellectual property matters in India. Now the appeal would lie before the High Court. So if a person who has filed a patent is affected because of an order out of a pre-grant opposition, then he can file an appeal before the High Court, because he doesn't have anything further to that. His patent is refused because of this pre-grant opposition. Therefore, he can go on appeal. But the person who files the opposition, if the controller deems that this patent can progress forward, this opposition is not worth, he has several other opportunities to oppose. He can file a post-grant opposition, he can revoke the patent. So he has several opportunities, whereas the patent holder does not. Therefore, the patent holder can file an appeal against an order arising out of a pre-grant opposition before the High Court. So the opposition procedure at pre-grant stage is smooth and involves very few formalities. And as said, it can be filed by any party, including third party. So it is always preferable for companies to go for a pre-grant opposition rather than, wait up to the patent to be granted and then go for the post-grant opposition, show that you are a person interested. Rather than that, a pre-grant opposition is always a preferred method of combating against your competitors in any industry when you are keeping a close watch for their patents. Also, oppositions are less time-consuming, less expensive as compared to action in courts. So that is also one of the reasons why a pre-grant opposition can be preferred, rather than finally waiting for a patent to be granted and then going for a revocation action against the patent in the court. So a large number of patent pre-grant oppositions in India are normally filed by players in the pharmaceutical industry, also in the manufacturing sector, but mainly in the pharmaceutical industry, because there is rapid innovation and research happening in the pharmaceutical industry. Every molecule is important. Time is of essence. So if you notice something that your competitor is bringing out that is not novel, not inventive, known in the art, probably based on some prior knowledge, probably not disclosed properly, has not followed any of the statutory steps. So the easiest way is to file a pre-grant opposition. Of course, other industries are also following suit. Now, all the other industries are also going for a lot of pre-grant oppositions. There are favorable orders that have been obtained in pre-grant oppositions by players when they file. So that is also an encouragement that has been given by the government, the controller of patents, to applicants who file for pre-grant oppositions. So this is all regarding pre-grant oppositions. I think I've covered the law the procedure, the grounds, and also some of the various cases that have been dealt with by courts in India. If anybody has any queries, I'd be happy to answer.
Thank you so much, ma'am. That was a very informative and exhaustive session on pre-grant opposition. The participants will be posting their queries in the chat box, ma'am. So far there was no queries. We shall wait for some time so that if there is any query, let them post.
Sure.
Ma'am, may I ask one question?
Yes.
Ma'am, suppose that in somebody has filed, just want to file a pre-grant opposition after the hearing has been complete by the between the applicant and controllers. So if at that stage, if somebody file a pre-grant opposition, so what procedure has been followed? How it goes?
See, a pre-grant opposition can be filed after publication at any stage, whatever stage the patent is. So normally the pre-grant opposition is taken up only after request for examination is filed. So come again, your question is what happens if, which hearing happens?
Suppose like that FIR has been issued and applicant has replied that FIR and hearing is also happened. And at that time, if the pre-grant opposition has been filed, so all the procedure is repeating or how it goes? Like what?
Whatever stage the pre-grant opposition is filed in, it has to be taken up by the controller because somebody is raising an opposition against the grant of that particular patent. So whatever stage it is in, even if it is at the penultimate stage and the application has been examined, he has filed a reply to the examination report, even the hearing is over.
Yeah.
Before the controller's decision, on whether the patent has to be granted or not, like a pre-grant opposition comes in, then he has to go ahead with the pre-grant opposition also. He has to ask the applicant to, file whatever reply they have to that. He has to consider the statement and evidence of both parties and he has to take a decision.
Okay. Thank you. Thank you.
Ma'am, no other queries were posted in the chat box, ma'am. Priya, you formally propose the vote of thanks, Priya.
Yes, ma'am. Good evening, everyone. It's an honor to propose the vote of thanks for today's session. I would like to thank the Almighty for making today's session a success. I extend my gratitude to our speaker, Mr. Lakshmi Devi Somanath, for taking the time to be a part of the FDP and research and IPR and for sharing her knowledge and insights. I thank all the participants who have taken time to attend today's session. A big thanks to our Secretary and Associate Secretary for the constant guidance and support. My special thanks to our Principal, Dr. S. Batmavati, and Vice Principal, Dr. S. Rukmani, for giving us the encouragement we always need. Last but not least, I would like to thank Dr. S.T. Deepa, our internal training team and the internal technical team for all the efforts and coordination. Once again, I thank you all. Thank you, ma'am.
Thank you so much, ma'am. Thank you. It was really an exhaustive session, ma'am. Thank you so much.
Yeah. Thank you, everybody. I'm glad to be part of this. Thank you.
Participants, the feedback link is posted in the chat box. You can just fill in your feedback.